hello there, everyone, everybody in the room, and everyone who's watching this online, and welcome to our Pupilage Open evening. We hope tonight that you will find out that we are a friendly and collegiate chambers, and those of you in the room are very welcome afterwards to come and join us for networking, and those watching online will be able to do the Q&A. And in that respect, I think some of you may know that we won Legal Cheek's Best Chambers for colleague supportiveness. So there you go, we're a friendly and supportive place to work. But we're also a place to work that does work at the highest level. So recent Supreme cases that we've been involved in include Worcestershire County Council and the Secretary of State for Health and Social Care, Imam and the London Borough of Croydon, and Finch on behalf of Wheeled Action Group and Surrey County Council, and that last one, a planning case involving quite a number of members of chambers arguing an important point on European legislation in the Supreme Court. So we do work which really covers everything from the Magistrates Court to the Supreme Court. And not only that, we think we do work which is central to the big issues that we are facing as a society today. And some of you may have seen that we've recently set up a climate group to bring together everyone in chambers who does climate work, but that's just one example. We do housing work, we do work around infrastructure, we do work around water protection, all the sorts of areas. It's amazing how many times you wake up and you listen to the Today programme and they're talking about exactly the issues that you do in your day-to-day life, because I think really what we do is very all the issues are very important to society today. As well as being a really great place, I would like to say thank you all for coming tonight, and thank you all for everyone who's watching this online, because pupillage is absolutely crucial for us. I think you'll see from the quote on your leaflet, we've got a really superb set of junior barristers in this chambers, and that is in no small part thanks to our pupillage process and to our absolute determination to get the very best people into our pupillage process. So thank you for coming. I hope that you'll all want to make an application, having heard tonight. Pupillage is a challenging year. It pushes you, it makes you work hard, but we also hope that it's a year that can be fun, and we hope that we've set up a process that is fair in terms of assessment. So the first thing I'm going to do is ask Hannah Taylor and Jeremy Ogwell Harris, who are our current pupils, to come and talk to you a little bit about their background, about their experiences so far with pupillage. I think you've been here 3 months, is that right? Yeah, nodding. 2 to 3. Okay. And their experience so far with pupillage and potentially some pupillage tips if they can think of it. There we go.
Hi, I'm Jeremy. I'm going to cover sort of 3 things. I'm going to give you some background on what I did before pupillage, talk a bit about the work that I've done in pupillage, and then cover sort of my general impression of how pupillage has been. So by way of background, I did my undergrad in Edinburgh University, and I also did, and then I did the GDL, BPTC, and then did a master's in public law at UCL. I had a sort of previous career as a caseworker before this. So I spent 4 years at Hackney Law Centre doing housing and welfare benefits law. One of those years I was a public law supervisor as well. And then I spent 6 months part-time at Southwark Law Centre running their planning project. And about 1.5 years teaching public law at Queen Mary University part-time. So for me, Cornerstone felt like a perfect fit because of their specialty in public law, but also particularly housing and planning. So what have I done so far? Well, it made a lot of sense for my first supervisor, who's sitting at the back of the room, to be a housing supervisor, given my background on that. I've done a mix of stuff with Andy, which has included sort of your bog standard housing cases, possession proceedings, homelessness appeals, homelessness reviews, but also some stuff that I hadn't done before, including licensing. So issues with housing conditions where the local authority wants to take enforcement action or rogue landlords. The sort of work within that, you'll do a bit of drafting, research, sort of writing advices or opinions. Also advocacy tasks, I'll touch on that in a bit, and generally shadowing your supervisor, so going to the board, watching what they do, stuff like that. So I've had a really interesting range of work from Andy so far. For example, last week we responded to a judicial review application for interim relief, which was basically about, it was kind of a jurisdiction case, so which local authority should be providing accommodation. And we successfully established that the claimant had a suitable alternative remedy. So essentially they have to go to the other local authority to sort that out. Something that was really great about that is I drafted a very first draft. And Andy, took my draft seriously. He took the points that I made seriously, and I really felt like I contributed to that, which was really great. Another example is watching Andy do a housing fraud case, which is his one of his big specialties. And kind of watching him do cross-examination, make submissions, how he deals with evidence. I also got to cross-examine Andy, and he pretended to be the witness, which was terrifying, but a great learning experience. And then, for example, tomorrow we're dealing with a upper tribunal appeal. That's equivalent jurisdiction to the High Court. Dealing with banning orders, so preventing rogue landlords from being landlords anymore, and whether the first year tribunal can take into account convictions that have become spent under the Rehabilitation of Offenders Act. So it's a good mix of stuff, and I found that really interesting. But Andy's also been super helpful in sort of getting me work outside of the housing stuff. So he's constantly asking other members of chambers, do you have anything you can give Jeremy that's not housing? So for example, I've done some advice for Rowan Clapp dealing with the fire safety order. I've done some work with John Fitzsimons about the Environmental Protection Act and statutory nuisances. And I went with Ruchi Parekh to a Court of Appeal hearing about the Sizewell C nuclear reactor and the scope of assessment under the habitats regulations. So it's been quite a broad range of really interesting stuff. So my overall experience, I think the first thing that I've enjoyed the most is my background of being a caseworker. I did not have a lot of supervision, so you kind of try to work things out yourself, and it's been really, really helpful having other people look over my work and be like, well, you said too much here, or you're making it too complicated, make it more simple. This is how you can be more persuasive. Second, everyone's been really friendly and supportive, and that's in all sorts of ways. So I talked to a KC the other day about how to get the printer to work because it wasn't working for me. Clerks have been super supportive. There's been some cases that I've been interested in being involved in, and they were happy for me to go talk to them and sort of tell me who was dealing with those cases. Everyone has open door. You can go chat to people. That's okay. I think the first day we were here, we had tea, and everyone who was in chambers came down and had tea with us and sort of introduced us into chambers. And finally, and probably the most important thing is that the work has just been really fascinating, and it's exactly what I wanted to do. So overall, I've really been enjoying Pupilage. Just in terms of tips, one thing I said, it took me 5 years to get Pupilage, 5 years of applying. It can be really difficult. I think just focus on your own well-being during that time, and remember that it's not necessarily about you, and you just have to keep trying. Everything from me.
Hi, I'm Hannah, and I hope I'm not going to cover too much of the same ground that Jeremy's already covered, but I'm also going to give a sort of overview of my background, an overview of what I've been doing in Pupilage so far, which is quite different to what Jeremy's been doing, and then sort of give my impressions of Cornerstone in general, and Pupilage at Cornerstone. So I came differently to Jeremy straight through education, so I did my undergraduate at Oxford, and then I did BCL. I applied for Pupilage in that year, very lucky to be successful, and take up Pupilage at Cornerstone. I did my bar course last year, and now I'm here. So I don't have the glittering past career that Jeremy has. I've kind of come straight through. And my background academically was in sort of environmental and human rights law. So again, that seemed sort of Cornerstone seemed like a very good fit for me. In terms of Pupilage, so my first seat at the moment, I'm sitting with Alex Campbell, who does a bit of housing work, but a lot of court protection work. For anyone who doesn't know, because I definitely didn't really know much about the court protection when I started, the court protection is a court that has jurisdiction to make decisions for people who lack capacity to make those decisions for themselves. And Alex's main work, and I believe the main work of people who work in at Chambers, is in making decisions for people around their health and welfare rather than around their property and affairs. So that's mainly what I've been looking at. And we do a range of cases such as depriving people, cases where people have been deprived of their liberty and they might be challenging that deprivation or making decisions in their best interests, even if that doesn't amount to deprivation of liberty, and dealing with a range of different scenarios for people in hospital situations, in care homes, or in the community in that capacity. Now, I have to say, I found the court of protection a really fascinating area of work, and it's a very different kind of jurisdiction to anything I'd come across before, because it's a lot more inquisitorial and collaborative. And so I've had a really great opportunity to learn sort of different procedures that don't crop up in sort of housing and planning law. Like, for example, often before a hearing, you'll have a roundtable meeting where all the parties in the case get together and try to narrow the issues and agree as far as possible the terms of the order for agreement by approval by the court, which has been something I didn't know anything about. I found really interesting, and it's a very different style of advocacy. So I've really enjoyed observing Alex doing those roundtable meetings. One thing I would like to stress is, as I mentioned, I knew nothing about the court of protection before 2 months ago, and that wasn't a problem. Alex has been really great in sort of getting me up to speed, and very patient with me while I ask lots of questions about how it works. And I feel now that I have got a fairly decent grasp on what's going on in the court of protection. I just say that because I don't think anyone should be put off applying if they have an interest in one area of Chambers' practice and maybe they don't know anything about other areas. I certainly was in the position of having a background in environmental and human rights law and not a great deal in court protection. And actually, I feel one thing I've really enjoyed is sort of, as in the last couple of weeks, I've been able to sort of see cases almost all the way, sort of a hearing all the way from start to finish. So I've attended the roundtable meeting, then I've drafted a draft order, and Alex amended it, and then I've drafted a position statement that's then been sent in filed with the court, and then I've attended the hearing and sort of seen the outcome and the final order for approval. So that's been a really nice way of seeing the sort of whole procedure in the court of protection. So that's really great. And the other thing I just wanted to mention about sort of my pupillage experience at the moment is that I'm in court quite a lot, which is really interesting. Court of protection has a lot of hearings, there's a lot of roundtable meetings, which obviously isn't court, but it's a type style of advocacy. And Alex also does housing work, which requires us to be quite a bit, which I found really great, because when I was applying, I don't know if the same still applies, but a lot of the minis that I did were remote because it was during COVID, or they were papers based. And so having that experience of being in court quite regularly, getting used to that, has been really interesting, and definitely I think will stand me in good stead for starting my second six, where you're on your feet quite a lot. So I'm sure Lois will talk about when she gives her sort of bit of this presentation. And just again, beyond doing the work with Alex, he's also been really good at sort of, as Jeremy said, getting me to be able to experience work in other areas of Chambers. So just as an overview, I've done some work on a very interesting landlord case involving a lot of easements and difficulties about implied easements. I've done some cost submissions, which is not something I've ever done before, so that was interesting. I've done a summary grounds of resistance in a housing judicial review and some submissions for an environmental law case. So those have all been really interesting ways of seeing the range of practice at Chambers. And the other thing that's been really great about my pupillage experience so far has been the opportunities that Alex has sort of made happen for me to shadow more junior members of Chambers, so that I get an idea of the work I'm likely to be doing in my first kind of second 6 months of pupillage and in sort of early years of practice. So for example, I've attended some gas injunctions and possession hearings, which has been really good to get that experience of what I'm likely to face come April. So that's been great. Finally, just about Cornerstone generally, not to sound like a broken record, but it is a genuinely wonderful set and really, really friendly. Something that I was really grateful for was that before we started our pupillage, obviously you get your offer 18 months in advance of when you start, and it can feel quite, you can feel quite detached from starting if you get your offer in May 2 years before and you have to wait that time. But Cornerstone have been really great at inviting us to housing day, planning day, the summer party. We had an induction 2 weeks before we started at Chambers. So it felt when we started that faces were familiar and I wasn't walking into a sea of unknown people. So that was really a way that I feel like Cornerstone have been very inclusive and welcoming. And yeah, just the other thing that I would say about Cornerstone is that the range of work is really amazing. I think we've touched on probably just about every area that Chambers work on, but yes, doing housing, planning law, court protection, licensing, information law, there's something that's sort of very interesting for everyone, and I've really enjoyed being able to get experience of all of that. So to conclude, this is a really welcoming Chambers. It's a fascinating practice area and I've had a great 2 months. Claire asked me to think about any tips I might have for pupillage. I think she's going to give you all of the really useful ones, but the only one that came to my mind was, I think, to be authentic in your application, and hopefully the one thing you can take away from both mine and Jeremy's experiences is that you can have completely different backgrounds and completely different experiences and still have, you know, a brilliant shot at pupillage and a really great experience at the bar. So I hope that's helpful and hopefully look forward to seeing some of you at drinks afterwards.
Thank you very much, Hannah and Jeremy. We're now going to hear from Lewis, who is our newest tenant, having just finished pupillage with us this time round. Unfortunately, she has a miserable cold, so rather than infect everyone, she's womanfully decided to do her talk from home. So hopefully, can you hear us?
I can hear you. Can everybody hear me in the room?
Yes, we can. I'm going to hand over. The technology
Excellent.
works.
Thanks, Claire, and thank you everybody for coming along. I'm sorry I can't physically see any of you. As Claire said, I've been sneezing all over the place today, so I thought I would avoid infecting all of you. I'm mostly here to talk to you about your second six, when you start or when you're second half of your pupillage, and the transition to tenancy at the end of your pupillage year. But first, I'm just going to say a very few words about my background before I joined Cornerstone, just to show again that people can come to pupillage and to the bar from a variety of different career paths previously. So the eagle-eyed amongst you may have spotted that I'm Dr. Lois Lane. I always feel the need to tell people that I'm not a doctor of anything useful, because I did a PhD in medieval history before doing anything else in my career. So I have a PhD in medieval bishops. I can't say that it's been hugely relevant to my legal career so far, but I did that first. I then worked for several years in the charity sector, on housing and planning policy issues for a couple of different charitable or trade body association organisations. And then at the beginning of the first COVID lockdown, I did the GDL and then the bar course and made the transition to the bar then. So it was a bit of a circuitous route to pupillage, but a lot of the things that I picked up in previous careers were very useful in terms of the skills that I picked up, even if the content was quite different. And that's something that I think you'll probably hear from Claire in her sort of top tips section at the end of these presentations, that it's really important when you're thinking about applying for pupillage to think about not just what legal experience you might have, but all of the experiences that you've had in your lives and careers and the extracurricular activities you might have done while you're studying, because those transferable skills can be hugely important to your ability to be a good barrister. If you've done research degrees in other subjects, you've learned how to work independently, you've learned how to set your own deadlines and juggle competing priorities. Maybe you've worked in hospitality and that shows that you can really deal with high pressure situations, deal well with other people, work in stressful circumstances, and make sure that you maintain a professional appearance or sort of professional demeanor at all times while you're doing that. So never write off any of the experiences that you've had as being irrelevant, because there are almost always useful skills that you will have picked up that you can transfer to the bar. And we've had a question on the online chat about mini pupilages and applications for mini pupilages and how one can stand out when doing that. And I just wanted to say one thing very briefly on that point, that when I was going through the pupillage application process and preparing for my pupillage applications, I had no luck at all with mini pupillage applications. So just this isn't necessarily a particularly good answer on how to stand out, because I clearly wasn't doing that right. But just to say that if you are applying for minis in places and you feel like you're not getting anywhere or you're not getting as far as you would like with that, try not to be disheartened. It doesn't necessarily mean that you're not going to get any interviews in the real pupillage application round. Bear in mind that the processes for applying, while there's some overlap, aren't absolutely identical. And certainly if you've applied for a mini pupillage at a set that you're really excited about, and then you don't get an offer of a mini, do still put in an application for pupillage there, because it absolutely doesn't mean that you've got no chance of getting an interview at that set. So those are just a few things to start with. But to talk about the main thing that I'm here to speak about, which is the transition to your second six. So like a lot of sets, Cornerstone has a first 6 months where you're just doing work for your supervisors and other members of chambers and shadowing members of chambers. And then you have a second 6 months where you're taking on your own caseload as well. And it is a nervy time. I found my first couple of months of being on my feet extremely nerve-wracking. I thought that because I'd done a lot of quite public facing work in the past, that I was comfortable with public speaking, that meant that being in court would feel quite normal and quite okay to me, and that I would find it quite a sort of smooth transition. I was terrified. I had probably about 2 months of feeling a little bit queasy before my hearings. So I would say that no matter what your previous background is, that can be a real shock to the system when you're first tasked with standing up in front of a judge and making a case on behalf of your client, no matter what you've done in previous roles, unless, like Jeremy, you have a lot of court experience already. So nerves are normal. The good thing is there will always be people in chambers to help. And I found that absolutely invaluable in my first few months of my second six. It's something that everyone says about Cornerstone, but it is so true. It's an extremely friendly, supportive, collegiate chambers to be part of. There was every time I had a panic because I didn't know what this type of hearing that I had to do the next day really entailed, or I realized that I'd had the papers through and then there was a deadline that had already passed and that I hadn't received all the stuff I needed to get things into court. There was always somebody who I could go to who would be able to calm me down, reassure me that it wasn't the end of the world, talk me through what the procedural steps were that needed to be taken, and advise on any of those sort of matters, which can be very new and very intimidating when you're starting out. So on that note, communicate with the people around you. When you find yourself juggling ongoing work for your supervisors that you'll still be doing, and also your own caseload, talk to your supervisors about how you're managing. If you've got a particularly busy court week, make sure that they know about that. If you're going to need a bit of extra time to complete a piece of written work, make sure you ask for that in good time. They will understand. They know that this is all brand new to you. So make sure you communicate with your supervisors, make sure you communicate with the clerks. Sometimes you will be asked about whether or not you want to do a piece of work or a hearing, and you'll look at it and you'll think, I don't know if I can do this. It looks really complicated, or I don't think I've got enough time, or it's a type of hearing I've never done before and it's tomorrow and I'm not sure if I've got if I can really get up to speed in that amount of time. Explain that, explain your concerns, ask questions, ask what they've heard from your instructing solicitor about how much time commitment it might be. If you really think that it's going to be too much, say so. You are allowed to say no to things. You don't have to accept absolutely everything that comes through. In fact, it's much better to say no to something because you know that you won't have the time or you won't yet have the skills to do a good job than it is to say yes and then not do your best work. So communication is key. Make sure you're talking to people. Make sure that you are asking questions if you're stuck. Make sure that you're communicating problems if any arise. And there will be times when you make mistakes and you'll freak out and you'll feel like it's the end of the world, and it won't be. It will be fine. So I think that's probably the main advice I would say on second sixes is that it's a hectic time and it's a steep learning curve, but you will get to the end of your second six and look back on where you were 6 months ago, and hopefully feel a real sense of achievement at how much more sort of comfortable you are in the role than you were. And then, in fact, the transition to tenancy, personally at least, I found to be rather smoother than the transition from first to second six, because a lot of the work that you're likely to be doing as a second six pupil is quite similar to a lot of the work that you're going to be doing as a new tenant. So as Hannah was saying, be doing in Cornerstone a lot of first possession hearings, a lot of hearings to apply for injunctions, for a landlord to enter property to maybe check the safety of the gas appliances or the electrical appliances. You might be doing directions hearings in relation to housing disrepair cases. You might be doing planning enforcement hearings, so going to the magistrates court and doing pre-trial preparation hearings for planning enforcement offences or statutory nuisance. So there's quite a range of types of hearing that you could be exposed to early on, but you will fairly quickly get a sense of what those different sort of common hearings are likely to be. In terms of a typical week when you're early on in tenancy, you will be in court quite a lot. So most weeks I'm in court maybe 3 or 4 days in a week. I had a couple of weeks ago where I had 6 hearings in 6 different courts in 5 days, which I wouldn't necessarily recommend as a strategy. But yeah, you'll visit lots of different courts. You'll get very familiar with lots of different types of hearing, and that's all really great. And then gradually you will also start to be brought in as a junior barrister on larger cases, whether that's planning inquiries. I've got my first planning inquiry in a couple of weeks, whether that's judicial review proceedings, whether that's housing related trials. We've got one junior member of Chambers who spent a big chunk of his first 3 months as a tenant involved in a really long, complex trial around gang injunctions, for example. So there's a huge range of work that you could be exposed to early on. But at the same time, you'll also be still doing those kinds of small hearings that you start out doing in your second six. So in that sense, the transition to tenancy is quite a smooth one. And the learning process obviously doesn't stop when pupillage stops. Everyone understands that you will still have questions sometimes. More senior members of Chambers are always on hand to support you in that process, and to make sure that you still feel as though there are people that you can ask questions of if and when you need to. So that's, I think, my main takeaways about my experience of being a second six pupil and a very new tenant. Please do ask me questions in the Q&A if you would like to. I'll make sure for people that are actually physically present in the room that my email address is included in the follow-up email that you'll get. So if you have any specific questions about what I've been talking about, do get in touch with me, and very best of luck with all your applications.
Thank you. And I think there's a couple of points that are really useful in what those who said. In particular, we really do get our pupils and our junior tenants into court in this Chambers, and that's not something you'll find in all the public law chambers. There's certainly some where their pupils barely darken the door of the court, whereas certainly our pupils are in chambers, I would say 2 to 3 times a week from their second six. And it's a really good grounding in advocacy and something that you don't get everywhere. So I'm going to talk a little bit about the application process, some top tips. If we can go on to the first slide, please. So the most important thing, if you remember nothing else today, is how to find our pupillage section of our website, because we've cunningly hidden it. So when you go onto our website, you'll see there's 3 lines on the right-hand side. I've circled it for you here. Next slide. If you click on that, it brings down our chambers, and you'll see down there, there's the pupillage section. If that foxes you, don't worry, it foxes me every time I look for that. But there you go, 3 lines on the right-hand side, pupillage section. And if you go on to the next slide, you'll see that on our pupillage section, this is just the first part of it, we've got an awful lot of information. And in fact, most things that I'm going to say now are probably somewhere on our website. So don't feel you have to frantically scribble everything down. The website is the important place to find everything. And we do try and keep it up to date. And also on there, I'm afraid, is a video that I did giving you these tips, which is probably quite similar to what I'm going to say today. So if you can't remember everything I've said today, do go on there and have a look at the video. So next slide, please. Yeah, so the first part of our process is the form sift, and we get every year, I think, in the region of 200 odd applications. That's an approximation, and we interview 20 people. So as you can probably tell, this is the point at which most applications don't go any further with us, and this is the thing you absolutely have to get right. In the past few years, you have had to get either full marks on the form or only drop maybe 1 mark to get through the interview process. So however good you are, we can't, we won't be able to meet you and understand what a brilliant advocate you're going to be unless your form can get through our process. So that if there's one bit that you absolutely have to pay attention to, it's this form. And we mark the form against the criteria that I put up on screen. It's all on our website. But we've essentially got 6 headline criteria. So intellectual ability. Now, intellectual ability doesn't just mean academic background. Obviously, that's how a lot of people do demonstrate intellectual ability to us. But think about how you can show us that you can take into account complex ideas, you can process difficult information, you can come up with persuasive arguments about that information. So sometimes maybe people have had a previous career where they've had to deal with those kind of things. Perhaps people who have done things like write articles for journals, anything which might show that you've got the ability to, deal with complex ideas and present them in an understandable way. Personal qualities. I always say this doesn't mean we're trying to find someone who, replicates us. That's definitely not what we're trying to do. We're looking for people who can show us self-reliance, resilience, independence, integrity, reliability, and capacity to work with others. And I hope it's fairly clear why all those things are crucial to being a good barrister. We're looking for people who understand the legal profession. So have you thought about what you're trying to come into? A lot of people demonstrate this through things like mini pupilages, through marshalling, through a background, like Jeremy was explaining, has a background in having had a previous legal career. That's obviously not at all essential. Some people have been to solicitors' firms, obviously people who've done mini pupillage with other sets. All of that shows us that you've thought about what you want to do. Interest in chambers work. Now I'll show you in a moment, there's a question directed specifically at this, but is there evidence on your form as to why you're interested in chambers work? I mean, anyone can write, I want to be a public lawyer, but does your form support that? Can you show us that you've done activities, taken steps that reflect that interest. I mean, a lot of people say, I want to be a public lawyer because I enjoyed it at university, or I want to be a planning lawyer because I listened to the Today programme and thought it was jolly interesting. That's fine, but what we really need to see is evidence. So, you know, can you show us that you've, for example, some people write for blogs about planning law, or some people join the Planning Law Environmental Bar Association. I'm a planner, that's why I tend to go for planning examples, but obviously housing examples are the same. So yeah, interest in chambers work, understand what we do and provide evidence as to why you want to do it. Oral advocacy aptitude. It's extraordinary how many times I read a really good form and I get to the end and I think they've not given me any evidence that they could be an oral advocate. So a lot of people show this through mooting or through other forms of public speaking. If you've done it, absolutely make sure you get it on your form because we need it to give you the points. But if you haven't done that kind of thing, can you think of other occasions where you've had to do oral advocacy? So, for example, if you've had a previous career, have you had to do public speaking? Have you had to present? In your extracurricular activities, have you had to try and persuade people orally? Have you had to take meetings? All these kind of things can be evidence of oral advocacy aptitude. Finally, written advocacy aptitude, and we're looking here predominantly at your form. So there's really two aspects of this. One, is your form itself well written? So please, we don't want flowery language, we don't want hugely convoluted sentences that you have to sit and read 3 times before you can work out what someone's saying. Just use clear, simple, persuasive language, and that's what we're looking for, someone who can do that and persuade us that they've got the aptitude to be a good barrister. But obviously also, if you've got anything in your background, so for example, a lot of people have worked somewhere where they've had to précis articles, for example, anything which can show us you've got a good ability to write, put that on your form as well. Those are all points in the written advocacy aptitude. Next slide, please. Yeah, so if anyone's applied to us before, we've slightly changed the questions, the bespoke questions on our form this year. Why do you believe you will make a good barrister? Obviously, what we're looking for here is evidence, and that's the same throughout our form. So, you know, you could write, I think I would be a really good public speaker and I would be really good at doing the opinions, but that's not going to allow us to put any points in any boxes. So, you know, I believe I would be a great advocate because I have this experience, I won this mooting competition, I persuaded an entire board of a charity to change tax because in this example, you know, I think I have the intellectual ability to do it for these reasons. It's your opportunity to really tell us what evidence you've got. Why do you want to apply to Cornerstone Barristers? Hopefully you'll do some research about us and can give a good reason about that. Which areas do you want to practice, specialise in, and why? Again, as I say, it's evidence we're looking for. So you can say, I want to be a public lawyer, or I want to be a planning lawyer, or whatever it is you want to do, but we're looking for the why, the evidence. And obviously, identify a time when you found working with others a challenge, explain how you overcame the challenge. This is giving you an example to talk about teamwork, and make sure you think about not just a time when you found working with others a challenge, but explain to us how you overcame the challenge. And think very carefully about this one. It's a surprise how many people say to us, give us an example where how they overcame the challenge was basically bow-greeting everybody else into coming to their own conclusion. I mean, if that's how you think you work well with others, fine, put it down. But I'm just saying, we're not always that impressed by that. We want to know about people who can genuinely work with other people. And then please give an example of the time you have to show resilience. Again, we're looking for all the boxes about personal qualities, resilience, independence. And then the last two opportunities to give us for you to show us how you can think a point through, how you can argue. So the first one, identify one aspect of the planning system you would change and why. We're not looking for anything complicated, but just can you think of something and come up with an argument for it, a sustained argument, and also have you done a little bit of research about the planning system? And the last question is obviously directed at public law. So I think you probably know the duty of candour in judicial review. We don't normally have to do standard disclosure in judicial review because there's this slightly nebulous duty called the duty of candour. So that's asking you, should we get rid of that and just have the standard disclosure rules? It's a bit technical, you have to do a little bit of research, but again, come up with an idea about it and just give us a few points, a sustained argument, so we can see that you can think through the areas we work in and come up with sustained, clear arguments about them. Thank you. Yeah, so here's my top tip. Number one, we're not mind readers. If there is anything at all that you've done that might be relevant to any of our criteria, please put it down on the form. We don't know that you used to work in a team at your when you were doing catering. We don't know any of that. All we know is what you put on your form. You know, there's no harm in making sure we get the message. If you've had an extracurricular job which you think really shows your independence and resilience because you had to balance that with working with full-time study, then tell us about that. Otherwise we just have to try and guess what might be these examples, and you might be missing out on points that you could get. Number two, don't give us an excuse to take away points. As I said, we've got to get all these hundreds of forms down to 20, and we have to be quite strict. And one of the easiest ways to take away points is through typos, I'm afraid. So read them, reread them, get someone else to read them, and read them again, because extraordinary how many times I go through a really good form and then find 2 or 3 typos, and I'm going to have to take a couple of points off, and that may well knock you out of contention. Number 3, a critical friend. Ask someone to read through your form, preferably not your mum who thinks you're all great, someone who's going to genuinely say to you, well, is this a really good example of that? Could you explain more about how you work with others? I think that's always really good to have another eye on it. And finally, I know I keep banging on about this, but this is how we mark the form: evidence against each criteria. If you don't have good evidence against each criteria, we cannot give you the points and your form will not get through. It's as simple as that. So that's the only way we can put your form through is if you give us good evidence against each of our criteria. So that's the forms. We obviously then mark the forms. They're marked blind of name, and we get rid of reference to things like gender and I believe school background. I can't remember exactly what we get rid of now, but we're trying to make it as equal as possible in terms of what the marker knows about you. So even if you think you've made a great friend tonight when you chat the drinks afterwards, I'm afraid we won't know it's you because we'll have taken your name off the form. Then we narrow them down to the top 20. They come to first round interview. That's typically about 15 minutes. It's usually a chat about things on your form. It's not there to catch you out. It's just really there to get to meet you, to be able to see you, speak to us. It's extraordinary how many people have got absolutely excellent forms and you meet them for the first time and can't actually string a sentence together. So there we go. It really is that simple. Obviously look back through your form, look at our website, try and keep in touch with important legal developments in our area, but we're not there to catch you out. We're not there to say, what did the 3rd judge in the Supreme Court say last week about the doctrine of X? That's not that kind of interview. It's assessed against the same criteria as we looked at the initial stage. And then the top 10 candidates from our first round interview go through to the second round interview. And that involves an advocacy exercise and a case analysis exercise. So what we've done in recent years is you'll get the advocacy exercise about a week before the actual interview. and you'll be asked to do a skeleton argument, just a short document, to bring to the interview with you. And you will then come to the interview about half an hour in advance, and you'll be given a case to read, and then you'll come in and do an analysis exercise on that. So those are the two most important bits, the case analysis exercise and the advocacy exercise. Obviously, there's also a few questions as well. So again, I would read back through your form and make sure you're familiar with it. But the advocacy exercise and the case analysis exercise are crucial. And then we pupilages. offer 2 pupilages. We offer it in line with the Gateway timetable. That is essentially the process. The one thing I haven't said, which is absolutely crucial, is that if there are any mitigating factors, we need to know about them, so put them on your form. Don't worry that we're going to think any less of you for any of your mitigating factors, but if there's something you think, put something on your form in context, please do put it on. I know some people, I've seen all sorts of things on the forms over the years. I'm not going to think any the less of anyone who's had any kind of difficult background, but we can only understand the context for your form if you put that on the form. So that's all we're worried about that. And the other thing is, if at any stage you want us to make any adjustments for you, then please do get in touch, and particularly when we get to interview. Obviously we will make any reasonable adjustments that we need to for anyone who needs them. So again, we can only understand that if you get in touch and tell us about it. So that is a slightly whistle-stop tour of our pupillage application process. As I say, it's all on our website. There's loads and loads of information on there. And obviously you can come and ask us any questions in the drinks now. Are there any questions that anyone would like to ask? Should we start off with the ones in the room and then deal with any online? Are there any questions in the room, first of all? Hi, yeah.
Thank you for the presentation, really helpful and interesting. My name is Gwen. Just a question. You spoke about how all of your experience is relevant. Is there a point, sort of looking back in time in one's CV, where prior experience is sort of less relevant because it's not very recent, sort of 3 years, 4 years, or would you just say you should just got everything?
I mean, I think the answer always comes back to our criteria. So, if the thing which shows you meet our criteria is 5 years ago, I would put it on. But I'm not very interested in the fact that you played grade 8 flute at school, because that doesn't tell us anything about our criteria. So that's really probably the judgment you have to make. If you've got something much more recent which shows you meet our criteria, that's probably a better thing to put on because it is more recent. But there's no reason at all why it can't be something older if that is what you have that shows that you meet the criteria. I mean, the grade 8 flute example, I don't care that you've got grade 8 flute, but the fact that you had to do that while you were doing your A-level and also holding down a part-time job might be relevant. So you just have to think creatively about all these different things that you've got that might help us put some ticks in some boxes. Is there anybody else in the room? No, are there any online that?
Oh yeah, we've got a couple.
Oh right, okay.
So the first comes from anonymous, who asks how much weight is given to the bar course grade, i.e. for the undergraduates, some changes require candidates to be above 2-1. Is there any similar for the bar course?
So in terms of degree, I think our requirement is that you have a 2-1 degree, or you explain what your mitigating factors are. I mean, typically people would have a 2-1 or better who are applying to us. So, I mean, to be realistic, if you haven't got a 2-1, you're going to have to explain in any event what your mitigating intellectual qualities are. In terms of the bar course itself, we don't have any particular criteria or play on that. I suppose potentially if you have an outside, that might go to a claim for intellectual ability, but we don't have any particular requirement about the bar course.
We've got another question from Huda Youssef, who asks, would any marks be deducted if I've not done a mini pupillage?
I wouldn't say that you deduct marks, but we do have a criteria about, well, we've got two criteria. We've got about knowledge of the legal profession, understanding of the legal profession. We've also got interest in chambers. So if you haven't done any mini pupilages, you might struggle to get some marks in the interest in the legal profession and the interest in chambers boxes. But obviously, if you've got other ways of showing that, for example, if you've had a previous career in the law, then I don't think I would worry too much about a lack of a mini pupillage. I mean, we do understand that in recent years it's been particularly difficult to get mini pupilages. So in the last few years, we've placed less weight on that in terms of applications because a lot of chambers didn't do them during COVID, and we know people haven't had access to them. And again, if you had to fund the bar course by working and you just haven't had the ability to do mini people, just put that on the form so we know, because otherwise we're just looking at someone who says they want to be a barrister but hasn't come to look at what barristers do, which is on the face of it a bit of a disconnect. But if there's a reason why that is, tell us. That's all we need to know.
And we've got a very interesting question from Curtis Crowley, who's asked, what are the biggest blunders you've witnessed in the interview stages?
In the interview stages, oh my goodness me. I mean, because I tend to do the second round interviews rather than the first round interviews, I wouldn't say I've seen a lot of big blunders, because by the time we get to the people who are at second round interview, they're all excellent, and it's really, I would say, fine margins. But we certainly at that point place a lot of weight on the advocacy exercise and on the case analysis exercise. So make sure you've done the preparation for the advocacy exercise. And read the case very carefully. So sometimes people just get the wrong end of the stick with the case, or their advocacy exercise is just pitched at the wrong level. They think they're going to get the person off, and we're thinking they're going to be sending them to prison for 10 years or whatever. It's not a criminal exercise. So that's a facetious example, but sometimes the advocacy exercise is just way off the mark. So I suppose it's probably quite useful to say about that. We do take into account whether you've done the BPTC yet or not, and whether you've done in advocacy training. So some people obviously have a clearer advocacy background than others, and we do try to take that into account. But yeah, those are probably the biggest blunders. Anything else?
I think that was our final question.
Lovely. Oh, well, thank you all very much for coming, and I hope to meet some of you in a moment for a drink, and thank you for everyone who's watched this online.